Good afternoon, everybody, and a very warm welcome to all for what is the first Institute National Branch meeting of 2021. My name is Jonathan Barber. I'm your host for today's webinar. Can I firstly start off by hoping that everybody is well, everybody's keeping well, yourself, your family and your colleagues. To all our practice members, we do hope you've come through January unscathed, maybe even managed a day or two off into early February and are now back to normal working life. But a very warm welcome to you all. Let me just run through a couple of housekeeping points, if I may. Please bear with us. If we have any technical issues, we will do our utmost to resolve those as speedily as possible. But as I say, please do bear with us. Questions, we hope you have many this afternoon. Please use the Q&A facility, which you'll either find at the top or the bottom of your screen, depending on your configuration, to type to post that question. Some will be answered along the way by Ewan Lawrence's colleague who joins him behind the scenes today. Others we will leave till the end and Ewan will take those one by one. I'll ask those for him and we look forward to his responses to them. So that's just some housekeeping. Small number of reminders to members. Everybody will have received an email in January about a slight change to the Institute's education programme, IFA Direct. I just wanted to remind all that we have changed partner and sort of provider of the education programme away from CU Coventry to an organisation by the name of ATHE, an Ofqual awarded and recognised body. The education programme has also been enhanced with a new number of units, with a rise in the number of tax units making up the qualification. So please, if you haven't yet looked at the units, the new education programme, do look at the website to see what's been going on and what's happening there. I mentioned this on a local branch surgery yesterday afternoon. There are a fantastic number of articles and content at the moment across the Institute's digital platform, Financial Accountant. So please do take a look at that, www.financialaccountant.co.uk. As I say, there's a range of information on there that I know many find helpful and useful. My final reminder is about renewals. That's both member renewals for 2021 and, where it's applicable to you, firm renewals for 2021. I'm sure there are many people on the webinar today who have already renewed, and thank you for doing so. But if you haven't, can you please look at the emails, the communications that the Institute has sent you and action accordingly. I often say this, but it's a reminder on two fronts. It's about renewing by paying the required fees, but it's also, from a member renewal perspective, about completing your mandatory member declaration. And if you have a firm and are renewing that as well, it is about paying the fees and completing the mandatory firm return. If there are any queries, any questions, anything that people aren't sure about with reference to renewals, then please make contact with us. Please make contact with the membership team. Thank you on that. Before I hand over to Ewan, I just want to run through a range of up-and-coming webinars that the Institute are hosting, are putting on for members. We start in a couple of days' time with a webinar that we've called Looking Back, Looking Forward. That's being hosted by the Institute's Chief Executive, John Edwards, and John will be joined by Ian Hornsey, an IFA board director, IFA branch ambassador for Essex, as well as Ian Clark, the Institute's London branch ambassador. That is to look at where we've been in the last 12, 18 months, where we find ourselves now, but where we are looking to move to in the future. We have a huge number of registrations already, which is fantastic for that particular event. Please do register, but we'd also like your input. So the questions that you want to know of your chief executive, of your board member, of your branch ambassador, please do give us your questions, your feedback. We want that to be an interactive session. For those on the webinar this morning who are just starting out in practice, I would strongly recommend you join us on the 23rd of February, the 2nd and the 9th of March for a series that is all about starting out in practice. One to, if you like, bring you up to speed with the Institute, how we can support you, how you might want to go about growing your client base, but also the regulatory issues you need to be aware of, the CPD requirements you should take into account, and certain information technology and AML issues it is very worthwhile being up to date with. The tax series returns next week on the 24th of February and is followed up on the 3rd and the 10th of March. We are covering during that series such topics as IR35, obviously very pertinent with the changes coming into effect from April. We're covering corporation tax, which will include deferred taxation, capital allowances, reorganisation and restructuring from a tax perspective, tax investigations and the budget. You'll see on the slide there are a number of future branch meetings planned on the 25th of February, the 11th and the 23rd of March. We will be holding 2 national branch meetings each month moving forward. There are a couple of technology-led webinars to be aware of, the first on the 2nd of March, the second on the 11th of March. We've also run, and we continue to run, a number of accounting treatment, financial reporting webinars. The first of those this year is on the 4th of March, problematic accounting areas. My understanding there is we'll look at everything from the prior year adjustments, accounting for stock, dealing with dividends and bonuses, as well as government grants. From a financial reporting perspective, there is also a quarterly update on the 25th of March. And then we're running a introduction, a basics to charities on the 8th of April. Behind all of that, the online branch surgeries have also started last week, and they continue this week and into next and beyond. So please, at a local level, you can join your nearest branch for more of an informal networking session, which, having hosted the Bristol meeting yesterday, and it was fantastic to see over 30 people on that particular meeting, it provides people with that local contact, some insight into 2 or 3 pertinent business accounting related areas, but an opportunity for members to talk, engage and share thoughts, problems and issues. So please, if you would like more information about the local branch surgeries, contact either myself or my colleague Linda Wallace. Enough from me and the Institute. I'd like to warmly welcome Ewan Lawrence from Black's Solicitors this afternoon. We're very grateful for Ewan taking the time to talk to us and update us around various employment law considerations businesses that have been impacted by COVID-19 might and should take account of and be aware of. Ewan is a solicitor partner in the employment team at Black Solicitors LLP. As it says on the screen, he specialises in providing clear, practical advice that covers workplace disputes and many areas of employment law. The good thing, I think, from our perspective, and for this particular webinar, is that that is predominantly focused around and on owner-managed businesses, the arenas in which our members find themselves advising and supporting clients. As you will see, Ewan has a wealth and a depth of experience. It's a delight, it's a pleasure to welcome him online today. I know Ewan and colleagues have welcomed members of our Leeds branch into their offices normally, but given COVID-19 and the current pandemic, we're all online and we continue to be online. So Ewan, very warm welcome to you. Thank you again for being with us. I'm going to stop sharing my slides and I will hand over to yourself, but thank you for being with us this afternoon.
Thanks very much indeed, Jonathan. Right, bear with me one moment and I will get my slides sharing. So, Jonathan, I'll ask you quickly whether or not you can see those slides now.
That's absolutely great, Ewan. Yep, can see those clearly. Thank you.
Fantastic stuff. Right. Well, thank you very much again to Jonathan and the Institute of Financial Accountants for the opportunity to speak to you today. And thanks for all of you who've dialed in to watch. Now, I anticipate that many of you will have questions about what we're going to cover. And as Jonathan alluded to, I am being assisted by my colleague, Lucy Melville. Lucy will be keeping an eye on the questions coming through on the Q&A function and or the chat function, and will endeavour to answer these in the chat as we go. And I can deal with any that are outstanding at the end. And if any questions do slip through the net, there will be a follow-up email coming through to all delegates with contact details for me and my firm. So do please feel free to forward any unanswered questions to me in the days to come. So what am I going to be talking about today? Well, I anticipate that all of the businesses watching and or their clients will have faced significant challenges over the last 12 months as a result of the COVID-19 pandemic. And I'd also hazard a guess that the arena in which many of these challenges have most obviously manifested is the relationship between businesses and their employees. So today's session will represent a relatively high-level guide to key employment law issues arising from the pandemic with which employers need to familiarise themselves, and I suspect will have already started to familiarise themselves over the last 10 to 12 months. Specifically, their health and safety obligations, the protections that are available to staff who are subject to an unsafe working environment, the potentially fraught topic of tests and vaccinations for staff, the changing working arrangements of staff, in particular, there's a significant increase in the proportion of employees working from home, making use of the coronavirus job protection scheme, employers seeking to alter employees' terms and conditions of employment, and sadly, the need to make redundancies. Now, that's quite a lot of topics. As I say, this is intended to be a pretty high-level canter through each of those areas, predominantly aimed at identifying key issues rather than a granular analysis of each area. Now, before we start, it'd be helpful for me to get an idea about the sizes of workforce we have on this call. I'm of course mindful that you will all here be dealing with owner-managed businesses, but it'd be helpful to know in terms of your own businesses what sort of size we're looking at. So if you could identify on the poll whether you've got 0 employees, between 1 and 4, between 5 and 9, or 10 or more, and I can see this moving around already.
It certainly is. I'm here to nudge those that haven't yet responded, so please do answer. It helps Ewan, and I think it also provides everybody else with a good idea as to, there are currently 143 people listening, to know what their fellow participants are, what sort of size of business we're talking about.
And thus far, and Jonathan, you'll know your membership better than I do, but it seems like the majority will have between 1 and 4 employees. Some won't have any. There's an equal number probably have between 5 and 9 and 10 or more. And is that sort of representative, do you think, of the demographic?
I think that's a very good split, actually. Yeah, I think that's a really good representation, Ewan.
Good, excellent. Well, that's helpful for me to know. And in terms of where this presentation is pitched, it seems to me that this is certainly going to have something for everybody. And of course, as I say, I anticipate that even those delegates who don't have any employees, they will have clients who have employees, and these issues will arise. So thank you very much all for participating in that. Now, on to the next slide. So let's start with a trot through the health and safety regime. Now, I should stress, I'm not a health and safety advisor, so what will follow it is a lawyer's guide through the relevant legal framework. And the first port of call for this topic is the Health and Safety at Work Act 1974, which sets out the duties on the employer and also the employee's responsibilities. Now, specifically, the Act places a duty on employers to ensure the health, safety and welfare at work of all employees, so far as is reasonably practicable. And this includes maintaining safety equipment, as well as giving proper training and supervision on all equipment, providing safe systems of work, ensuring any materials are handled, used, transported and stored properly and safely, providing a safe workplace and working environment, preparing a health and safety policy, making it available to all employees, and don't forget, looking after the health and safety of others, for example, members of the general public who use your services. And the Act's rules are not entirely one way. There are also obligations on employees who are required to, for example, take care of their own health and safety, as well as that of others. It's worth noting that employees can have personal liability in certain circumstances. They're required to cooperate with their employers, and they're required not to interfere with anything provided in the interest of health and safety. So what does this mean in the COVID-19 era? Well, employers need to have a look at their general duties under the Health and Safety at Work Act 1974 when deciding how to manage the risk presented by the virus. Now, the subsections of Section 2, which are set out in the next few slides, are relevant to the prevention of COVID-19, as they state that employers must, for example, as I say, ensure the health, safety and welfare of the employees. This is, after all, the overarching principle of the Act, but also provide such information, instruction and training to ensure the health and safety at work of their employees. So this could include general guidance and information on how to prevent the spread of COVID, or placing posters around the workplace reminding employees to socially distance, or encouraging good hygiene and regular hand washing. And they're required to provide appropriate facilities for employees whilst at work. So in the current context, this could include more hand sanitizer being placed around the workplace, boxes of face masks made available, antibacterial wipes to wipe down surfaces once used, and adequate hand washing facilities. Now, in my view, these obligations are likely to be felt most keenly where an employer's premises are due to be reopened to employees after a period of closure. And I'm sure we've all seen or been part of businesses that with repeated lockdowns and reopenings, we've had this quite a lot over the last 10 to 12 months. It perhaps goes without saying that before taking the decision to reopen, it's beholden on employers to conduct a thorough risk assessment and put in place measures to remove or reduce any material risks identified. Indeed, employers that are contemplating reopening may wish to use Section 2 of the Act, so the last few slides I've shown, as part of a checklist to ensure that they have all their ducks in a row. For example, have we got adequate systems to ensure regular cleaning of key touch points? Check. What about deliveries to and from the office? Check. How will we train staff to ensure social distancing? Check, etc., etc. Now, if employers fail to comply with their health and safety duties, they risk personal injury claims from employees for failing to control the risk, or even from service users if they've contracted COVID-19 because of these failures. There could be investigations from the health and safety executive. Companies and directors in their individual names could also face fines or indeed custodial sentences if they breach their duties. As for employees, they also need to be mindful of their own obligations, which will undoubtedly include following and complying with the guidance and policies of their employer, as well as any government or NHS guidance and rules aimed at preventing, the spread of the virus. Now, as well as claims directly arising from an employer's failure to maintain a safe workplace, there are additional protections available to employees who find themselves working in an unsafe environment. And these are set out in the Employment Rights Act 1996. The relevant parts of the Act from a health and safety perspective are sections 44 and 100, which respectively protect employees from detriment and from dismissal. Now, looking at detriment first of all, and by way of detriment, I mean, it's a fairly obvious term, but if you subject anybody to any disadvantaged treatment because of one of the things that we're going to be describing, suspend them or subject them to a pay cut or whatever, that is going to be a detriment. Now, I don't propose to look in detail at subsections 1A, B and BA. Suffice to say that if an employer subjects to a detriment any person who's been charged with carrying out activities in connection with preventing or reducing risks to health and safety at work, or performed functions as a representative of workers on matters of health and safety, work or as a member of a safety committee, or took part in a health and safety consultation or an election of health and safety representatives, and the employer subjected them to a detriment because of those activities, that is unlawful. And hopefully that doesn't come as a major surprise to anyone. There is obviously an important public policy interest in ensuring that those who are charged with performing a health and safety role can do so freely to the best of their ability without fear of retribution. Where it gets more relevant for most employers in the context of this pandemic is where either because there is no health and safety representative or where it's not reasonably practicable to go through a designated representative, ordinary employees have to take matters into their own hands. So there is specific protection for ordinary employees who reasonably believe that circumstances connected with work are harmful or potentially harmful and bring this to the employer's attention, or who reasonably believe that they are in serious and imminent danger, which they cannot be expected to avert, and therefore leave work, or, I suppose this is probably going to be more relevant at the current time, refuse to return to their place of work, or who reasonably believe that they are in serious imminent danger, take appropriate steps to protect themselves or others from that danger. Now, the key word in all of those subclauses is, of course, reasonably. The employment team at Blacks have fielded any number of calls from employers and employees over the last 10 months about situations relating to employees who have refused to return to work over health and safety concerns. Put bluntly, they're concerned about the risk of contracting the virus from coming back to work. You may recall, for example, before the current lockdown, a teaching union advising all of its members to send so-called Section 44 letters to their employers, notifying them that they'd been advised not to attend schools as they weren't safe. Now, our starting point when considering these sorts of questions is it reasonable for the employee to consider that the workplace is unsafe? In reality, no employer can guarantee that their workplace is 100% COVID secure. And the employer's obligation is not to entirely eliminate the risk, it's only to reduce it as much as they possibly can. So what in practice is required is an examination of the steps the employer has taken to make sure that the workplace is as safe and as it reasonably can be. So, have they conducted appropriate risk assessments? Do they have adequate facilities for regular hand sanitation? How have they ensured that social distancing can be maintained? In blunt terms, are they following the guidance from the government and Public Health England? Now we then move on to protection from dismissal, that's section 100 of the Act, which I can summarise briefly as follows. If you dismiss anyone for doing something that is protected under section 44, as we've just discussed, that is automatically unfair. Now, the consequences of automatically unfairly dismissing an employee are twofold. First, the usual 2 years minimum qualifying service that you'll probably all be aware of that employees normally need to bring a claim for unfair dismissal is no longer required. Second, the maximum cap on unfair dismissal compensatory awards, which is currently the lower of £88,519 or 52 weeks gross basic salary, that goes out the window, leaving the employee with a potentially unlimited award. Finally, a quick note to say that employees who raise health and safety concerns may well find that they are protected not only by the provisions of the Act that I've just mentioned, but also by those that protect whistleblowers. If they can argue that in raising their concerns, they were making disclosures of information which they reasonably believed were in the public interest and tended to show, for example, that a criminal offence, a failure to comply with legal obligations, or endangerment of health or safety was occurring or was likely to occur. And finally, it's also worth noting that employees may also raise concerns not just about the safety of the workplace, but also about the safety of the public transport that they need to use to get to the workplace. Now, in such cases, because sections 44 and 100 would not be engaged, the employer arguably has a more free hand to take steps against the employees in those situations, in some circumstances up to and including dismissal. But needless to say, even though sections 44 and 100 don't apply, employers do still need to be conscious of ordinary employment law principles relating to, for example, unfair dismissal and disability discrimination when we're referring to people who are, let's say, clinically vulnerable and were people who used to shield, let's say. Now, that then brings us on to the question of testing for COVID-19. There is in fact support available for businesses looking to test their employees. In an effort to ramp up workplace testing for the virus, the government has recently announced that businesses which are open during lockdown and employ more than 50 employees are entitled to order rapid lateral flow tests. Now, these tests produce results within 30 minutes. Previously, only businesses with more than 250 employees qualified for this type of workplace testing under the government scheme. And the government clearly hopes to encourage those sectors that are vital to the running of the economy and whose employees cannot work from home during lockdown to roll out workplace testing for all employees, whether or not they're showing signs of COVID. Because the government suggests that around 1 in 3 people who have the virus have no symptoms and may be unknowingly spreading it. Accordingly, an increase in workplace testing should help to limit the risk of transmission. Now, in view of the duty on all employers to protect the health and safety of their employees, as I mentioned earlier, it's our view that for those employees that cannot work from home, a request that they take a rapid lateral flow test in the workplace or as a condition of coming back into the workplace is likely to be deemed a reasonable management instruction, meaning that refusal of such a request is a potential disciplinary matter. Now, with that being said, it is important to note that these tests can be uncomfortable and invasive and need to be taken frequently. Therefore, before considering disciplinary action in respect of an employee refusing to take the test, employers should carefully consider the employee's reasons for refusing, their individual circumstances, and any mitigating factors. And I'd strongly recommend at that point probably taking legal advice in relation to any possible claims that there may be for example, disability discrimination or otherwise. Now, these concerns are even more important for those employers who are considering taking a vaccination to be a requirement of continued employment or indeed a condition of getting a job in the first place. Now, it's our view that such a condition is likely to be considered a reasonable instruction to staff in the context of hospitals, medical practices, nursing homes, and other organisations which regularly deal with clinically vulnerable individuals. However, this will not necessarily be the case in all businesses. We may get a better idea of how defensible it is for general businesses to introduce a policy of mandatory vaccinations from the experience of London firm Pimlico Plumbers, who were referenced on screen. You may have seen that recently this company announced that it would make having the vaccine a condition of employment for all those able to have the vaccine safely. And their rationale for this is arguably quite compelling. They say, what is the difference between a vaccination against a virus that can kill and a hard hat on a building site that may prevent death from a heavy object falling on a worker's head? Well, that's fine, but the obvious answer to this question is that the HSE has mandated the wearing of hard hats on building sites, but on the other hand, the government has clearly stated that it will not make it mandatory to have the vaccine. So we shall wait and see what comes of that situation. Now, flexible working is a working arrangement, as I'm sure you all know, which gives an employee a degree of flexibility on where, when, how long, and at what times they work. Different forms of flexible working include working from home, which we're going to come on to discuss in a moment, part-time working, job shares, and flexi-time. It can form part of the contract of employment, or it can be an informal arrangement agreed between the employee and their supervisor and taking place on an informal ad hoc basis. Now, before the pandemic began, around 5% of the national workforce mainly worked from home. But as lockdowns were introduced and restrictions came into force, more people started to work from home and also had to balance their other responsibilities, such as homeschooling or childcare. So we move forward to April 2020, 46.6% of people in employment worked from home at some point, with most, around 80.6%, stating that the reason was because of the impact of COVID. Employers, of course, need to keep in mind that the current situation is not reflective of what is normal, at least we all hope not going forward. And therefore, they should take care not to make any long-lasting decisions about flexible working purely on the basis of what is happening at the current moment in time. Now, another quick poll opportunity. This one's a bit more binary. After the pandemic has ended, do you anticipate that your business will want to facilitate more employees from working from home than it used to? Yes or no? And whilst people are filling that in, Jonathan, I don't know if you've got are you finding that in the in your own businesses, in your the clients that you work for, are they envisaging making more use of home working after the pandemic ends?
I think from an institute perspective, Ewan, we were fortunate, back at the beginning of last year, whereby, all staff, all colleagues had the facility to work from home, and a number of people weren't head office based. So actually, when we were all locked down for the first time, we were able to transition very quickly to home working. So all my colleagues had, laptops. They had, the sort of telephony to be able to communicate. So that's been good for us. I think from a member perspective, the feedback I've had of late and over the months has been everybody's adapted well. I think, like with any organisation, there have probably been a few teething problems. I'll answer it another way. I think where there are issue is maybe the wrong phrase or word, but when you've got to throw into the mix homeschooling, that's when I think it actually becomes tricky, because if you've got the laptop, the computer, the telephone, the mobile phone, you're probably able to help your clients, you help our members, help like you are your clients. It's the other factors that get thrown in that I think make it more complicated. As an institute, we've been talking about, and we continue to talk about, a return to work program from an institute perspective. Quite how that will play out, given the current situation, the daily number of cases coming down, the vaccination rolling out, who knows? But there is a plan that we're working towards. I'm sure a number of our members who go out to work, or their practice is not from home, are considering and are going to have to consider this sort of scenario. I would suggest as well, from a personal perspective, I think the working environment will change quite significantly. I think what we probably all were used to is not what we will be used to again in the future. So I think it's intriguing. And sorry, I'm just looking at the response there. I'm not surprised by that outcome or those figures. I don't know whether you would agree with that, with what you see.
I think that broadly resonates with my experience with the clients that we've got. I would say that there is a majority who are going to be making more use of home working and what have you. But it's not going to work for everybody. Even and as we're going to come on to see, whilst the pandemic has been a bit of a test run for many people for flexible working and home working, and often it has proved the benefits, it's also shown some problems, which I will come on to on the next slide. So thank you all for participating in that. That's enormously helpful. So if I move on then, and we're going promptly on to a slide that looks at some of the advantages and disadvantages associated with home working, some of which may resonate with you, some of which you may or may not agree with. It seems to me that there's a significant number you could argue either way. Speaking from a personal perspective, the points that really resonate for me are the benefits of the increased flexibility associated with home working on the one side, but on the other side, the challenges of erratic IT and really sometimes struggling from actually switching off from work when you've no longer, people sometimes complain about the commute, but that time spent in the commute is sometimes quite a useful exercise to be able to transition from work mode to home mode, which we don't really have anymore, unfortunately. Now, turning to the mechanics of flexible working requests, any employee who has at least 26 weeks service with their employer and has not made a request in the previous 12 months is entitled to make a statutory flexible working request. And when considering a request for flexible working, employers need to carefully look at the potential benefits and problems that the changes requested have, both for the employee and the business. And it's going to be interesting to see the approach taken in this respect by businesses who pre-pandemic were extremely resistant to flexible and home working. There are in fact only 8 legitimate reasons why employers might reject flexible working applications. So these are, firstly, the burden of additional costs, then an inability to reorganize work amongst existing staff, an inability to recruit additional staff, a detrimental impact on quality, a detrimental impact on performance, a detrimental effect on ability to meet customer demand, insufficient work for the periods the employee proposes to work, or a planned structural change to the business. Now, those of you who've been around in business for a while or are naturally cynical might reasonably say it's quite easy for employers to fit their reasons, to shoehorn them into one of those statutory reasons, and so it usually proves. Bear in mind, of course, that an employee does have the right to appeal any decision to reject their application for flexible working. If you do accept the employee's request with or without any modifications, you need to discuss how and when the changes are going to take effect. And the law requires all flexible working applications to be dealt with within a period of 3 months from receipt, unless extensions are agreed between both parties. Now, I do think this is important because I do think we are going to see, to the extent that we haven't already, a significant increase in the number of flexible working requests that are made. Now, one of the big issues that employers facing an increasing number of home workers will have to deal with is monitoring staff to ensure productivity. Happily, 2/3 of employers report that home workers are just as productive, if not more productive, than their colleagues working from the office. However, even with those figures, 1 in 5 employers are using or plan to start using monitoring software on those employees who are working from home. Now, if employers are planning on introducing monitoring software to home workers, it is important to be transparent about the changes. And employers should also ensure that they inform employees about what personal data they will be collecting from the software. And this may, of course, require an update to any relevant privacy notice. If employers want to monitor productivity without using software, there are, of course, other ways to do this, including staff surveys, observations, spot checks, even just talking to their employees. Now, I won't do a poll, but I'm willing to bet that prior to March of last year, no one on this webinar had come across the word furlough in an employment law context, me included. I suspect that we are all now heartily sick of that term. So, in that context, let's have a quick canter through the different versions of the scheme that we've had. Version 1 of the job retention scheme was announced by Rishi Sunak on the 20th of March last year and was available to any employers whose business had been negatively impacted by COVID. Employers could place employees on furlough under the scheme as long as they'd been on the February 2020 payroll, and the government will reimburse employers up to 80% of any furloughed employees' wages up to a maximum of £2,500 per month. Now, the scheme also allowed any employees who were made redundant prior to 28 February 2020 to be re-employed and placed on furlough leave. I'll double back to that point. Employees had to be furloughed for a minimum of 3 weeks at that time and were not allowed to do any work which could generate money for the business, but could do volunteer work or training. And no new employees could be placed on furlough after the 30th of June. Now, version 2 came into force on the 1st of July, and as I say, it was only available to employees who'd previously been furloughed under version 1. And this also gave employers, for the first time, the option to flexi-furlough employees, meaning part-time working was now available and there was no minimum period of furlough. If employers decided to flexi-furlough employees, they were required to make sure they kept an accurate record of what hours were worked and when. And it perhaps goes without saying, I don't need to tell everybody on this webinar that HMRC will be investigating claims made over the next 6 years. So the paperwork is absolutely crucial here. Now, the working pattern for flexi furlough could be changed week to week or day to day if needed, and the employer would pay for the hours worked and the government would top up to a maximum of 80% for the hours not worked. From 1st of September, the scheme began to gradually taper down the level of contribution provided by the government. And when the second national lockdown was announced in November, it was also announced that the scheme would be further extended. And this became version 3. The contributions from the scheme went back up to 80%, although employers were asked to cover the national insurance payments and pension contributions for hours not worked. It was open for employers to fully or flexibly furlough employees, and the only requirement was that the employee had to have been on an RTI submission made to HMRC on or before 11:59 p.m. on the 30th of October, meaning that employees that were hired in late spring or summer and who were not eligible for version 2 could be eligible for version 3. Now, although initially the reason for using the furlough scheme was a downturn of work and business due to the impact of COVID-19, in early January, the rules of the scheme were clarified to say that employees who were struggling balancing their work and childcare due to school closures could be placed on furlough for childcare reasons. It has, of course, also been the case since December that the government has published the identities of those employers who have made claims under the job retention scheme, and it proposes to publish further data, including an indication of the value of the claims made by the employers. It's not been confirmed yet whether the scheme will be extended beyond the 30th of April, although needless to say, if restrictions will remain in force in some form, lockdown or otherwise, there's going to be pressure on the Chancellor from business to support them past April. If there is to be an extension, it's thought that that's going to be announced in the budget statement on the 3rd of March. Now, with a lot of businesses experiencing a downturn in work, business. A lot of employers may, whether now or after flexi furlough is no longer available, look to amend their employees' terms and conditions of employment, and potentially that will be to reduce pay, reduce the hours, reduce other benefits. And these changes could, for example, start as temporary arrangements with regular reviews every few months before possibly becoming permanent. In either case, the employer will need to have the employee's agreement to the changes. Now, an employer considering reducing, for example, pay or hours or something as serious as that, should look first of all at the terms of their employment contract. Now, I think it's unlikely that an employer would lawfully be able to use a clause that, say, reserves the right to make reasonable changes to terms as a means of materially reducing hours or pay, let's say, as to do so, in my opinion, would breach the implied term of trust and confidence. They might, though, be able to make use of short-time working or layoff provisions if the contracts have them. Now, not a lot of employment contracts do have these provisions anymore because they were commonly associated with the factory and manufacturing sectors. And it's only been really since the pandemic that a lot of other businesses, including service businesses, have thought we might need these provisions in there. Now, if there aren't such provisions in the contract, employers need to get the employees' consent, preferably written consent, to any changes to pay or hours, or they risk claims in the employment tribunal for unlawful deduction from wages and or constructive dismissal. Now, where an employer wishes to impose changes to employment contracts, it is necessary to consult with staff about the proposed changes. If there is a likelihood that in the event the changes are not agreed, 20 or more employees could be made redundant, it's important to remember that the employer needs to collectively consult with employee representatives, either trade union representatives or representatives elected by the employees. And this process must last for a minimum period of 30 days, where it affects between 20 and 99 employees, and 45 days if 100 or more are affected. Generally speaking, employees are only likely to accept any significant change to terms and conditions if they can see a genuine business need for them and have been properly advised and consulted throughout the whole process. Even if employers need to act quickly to action these changes, and I recognise that that will be a real requirement for many businesses, ensuring that they try to take the time to lawfully implement them will limit the long-term potential risks in employment relationships, as well as obviously the risk of legal action being taken. In our experience of these cases during the pandemic, most employees are pretty receptive to changes to hours and indeed to pay up to a limit, if it potentially means the difference between a business surviving or a business shutting its doors and its staff being made redundant. Now, if an agreement cannot be reached between the employer and the employee may decide to dismiss the employee and re-engage them, or offer them re-engagement, I should say, on the new terms. Now, this is usually the last resort and something of a nuclear option. If an employer does decide to go down this route, they need to ensure that they follow a fair and proper dismissal procedure, give the employee their full contractual and statutory notice, and offer the employee the right of appeal against the dismissal. If the new contract starts immediately after the old contract ends, then the employee will keep continuity of employment as there's been no break in service. Now, finally, and sadly, we've already seen and are likely to continue to see a significant number of redundancies due to the pandemic. Although the job retention scheme does allow for some employees who've been made redundant to be re-employed and furloughed, I've got to be honest, the advice to employers normally is that there is little purpose in doing so where an employer has decided that the role is simply no longer viable even after the pandemic. It simply causes a headache for the employer. Now, as mentioned earlier, if 20 or more are at risk of redundancy, then the employer needs to collectively consult, as well as individually consult with employer representatives. And in addition, the employer is obliged to inform the Secretary of State for Business, Energy and Industrial Strategy by completing Form HR1 to notify the government that you're proposing to make 20 or more redundancies. Now, I set out on the slide a brief reminder of what a fair process for making redundancies look like. In essence, you need to start by identifying which individuals, pools of individuals at risk, apply objective criteria, not just last in, first out, I hasten to add, to decide which of these should be provisionally selected for redundancy, and then consult with them about any alternatives to redundancy that there may be. Bear in mind that redundancy is looked at as being the method of last resort. So employers are obliged to try and find alternatives. And of course, as with so many things, if you do end up dismissing an employee, you are obliged to give them the right of appeal. Of course, you might say that if they don't have 2 years service and they can't claim unfair dismissal, then there's not a great deal that they can do about it if you don't give them an appeal. But of course, we've already discussed the issues in relation to automatic unfair dismissal, so just be careful. What happens if you get any of what I've discussed today wrong? Well, chances are that you'll end up facing a claim in the Employment Tribunal. We foresee a very substantial number of cases relating to what has happened over the past 10 to 12 months will start to, and indeed already are, clogging up the Employment Tribunal system this year. The good news for employers, if I can call it that, is that the backlog within the tribunal system means that most claimants are facing waits of 6, 9, 12 months or longer to actually get to a final hearing. Now, to put that in context, Leeds Employment Tribunal is probably about the best in the country in terms of turnaround, and I still, even in Leeds, estimate 6 to 12 months as a general rule of thumb. In places like Cardiff, Central London, for many even preliminary hearings, you can be waiting over a year. Now, this in turn often incentivizes many claimants to settle their claims, and that is often for quite modest amounts of compensation. So there are levers on a practical level that employers can rely upon here. Well, that's all my slides dealt with. Now, I think that Lucy has been dealing with questions as we go. And I know, Jonathan, you've been keeping an eye on this as well. Are there any that have come in yet that haven't been dealt with?
I think this is more of an observation, a point really, Ewan, for you. Hi, Ewan. It might be worth noting that a number of insurers are refusing to provide cover for businesses providing lateral flow testing. Any firm doing it needs to check with their insurer. I don't know if there's anything you'd want to sort of comment on.
Absolutely fantastic point, and I'm grateful for making it. It's one of these situations, it seems to me, where the government has put forward, on the face of it, an admirable policy, but hasn't perhaps considered all the potential ramifications. So no, 100% right that before you do anything like that, the insurers need to be notified.
Yeah, no, I thank you for that. I've seen this question asked as you've been talking, Ewan, so I'll just double check or cover it off. I know we are sending all attendees an email on your behalf within the next 24 hours. Are we able to share your slides from this afternoon?
Absolutely. I was tempted to say no there, Jonathan, just to see your reaction, but no, of course, no problem at all.
Well, yeah, hey, that would have been the answer, wouldn't it? That's absolutely fine there. So I think somebody is asking, right, okay, I think somebody's asking the same thing there. There is also a recording of today's session, and my colleague will be posting that onto the Institute's YouTube channel again within the next 24 hours. So, attendees will have the slides as a reference. Secondly, if you've missed a piece and you actually wanted to hear Ewan's words, you can subscribe and access the seminar through the YouTube channel. Unsurprisingly, I'm also getting a number of comments, Ewan, and thank you. You know, great topic and speaker. So thank you already from a number of people who've attended today. Yes, I think I've answered the question that a couple of people have posed about the slides, so I can get rid of those. You know, you've talked about a number of things, haven't you? You've kindly run through health and safety. You've looked at furloughing, the furlough schemes, and the way that has evolved over the last 9+ months. You've talked about employment contracts, terms and conditions, and you've then sort of looked at redundancy. You know, are you as an individual or colleagues in a firm, are you seeing particular areas of concern or focus by SMEs currently?
Well, I suppose I'll probably answer that in two ways. Firstly, I'll state the obvious here, that a particular area of concern for the economy is certain sectors that have been worse hit than others. So in my opinion, most of my owner-managed clients and SME businesses, when it comes to redundancies and streamlining and so on and so forth, most of them have probably made, I would say, the vast majority of the redundancies that they need to make, and they've trimmed down, and they probably did that before October, so before the end of version 2, I think it was. The sectors who we are still finding, and this will come as no surprise to you, but we're still finding are in deep waters, are of course hospitality, the arts, and I suppose travel as well. And those are the sectors I think that it's going to be a real struggle for many of those businesses just to make it through, notwithstanding all the support that's been provided through the job retention scheme and whatever else. Making it through until we reopen is going to be a challenge. So that's one aspect. In terms of the things that that generally owner-managed businesses are specifically asking at the moment, I think I've covered some of them. I think that we've probably, I think that they are concerned about the do's and don'ts of having people back into work after this current period of lockdown ends. I think that there is a certain amount of fallout which is being dealt with in relation to furlough. So this may be employees that feel that their employers miscalculated their furlough wages, for example, last year. If I can be honest, I think, as I might have said during the presentation, I think a lot of 2021 is going to be the repercussions of what happened in 2020. I think in 2020, everybody was so concerned, understandably, with just getting things done and getting on with life as far as they possibly could, that employees and employers didn't often have, or certainly employees didn't really have time or feel the confidence to actually raise concerns or complaints about what was going on. So I think this year is when we're going to see that, and I suppose the majority of the calls that I'm getting from SME businesses tend to relate to problems with employees that have been in some way caused by what happened last year.
Yeah. Okay. No. It's interesting when the way you talk about it, and also, I suppose, the three sectors that I'm sure giving it thought. None of us would find unsurprising hospitality, arts and travel. Yeah, no, that's interesting. Thank you. Look, I'll just sort of ask again if there's anybody with any specific questions that they have for you and or want to ask. You know, there may be some people who are, you know, on the webinar this afternoon who have taken note of your contact details, or after the email that we send out on your behalf, come back to you, Ewan, because they want to keep the sort of the question offline, and it's a direct one with you regarding themselves or their organisation. So
I totally recognise that, and there will be questions. And I note that one I think has come up on the Q&A already, which are clearly sensitive, confidential, which don't want to be asked in this forum. As Jonathan says, that there will be an email with all my contact details if you didn't have time to get it from the final side, which I only had up for a fraction of a second. That'll be out in the next 24 hours. So please do come back to me on that.
Sorry, I do have one here, actually. I'm glad I asked again. Can an employer force the vaccine into his employees?
Yes, I mean that's it. It's a great question. The short answer to that question is no. An employer cannot, you know, physically force an employee to take the vaccine. That would be, it seems to me, unlawful. That would arguably be a breach of their human rights, frankly. What they and what I was discussing in the presentation, what they can arguably do, and especially in the context of a medical practice, a nursing home, hospital, etc., is make employment conditional upon them taking the vaccine, or make their ability to work in certain areas conditional upon them taking the vaccine. It's going to be I suppose it's going to require an analysis of the particular type of work that they do, and balancing the importance of them taking the vaccine. And bear in mind, of course, that we don't yet have all the data about the effectiveness of the vaccine when it comes to transmitting. About transmitting the virus. We know a lot about the vaccine's effectiveness for preventing individuals from suffering, as it were, but we don't know, I think, as yet, much about its impact on transmissibility. So I would be outside of those specific organisations dealing with vulnerable people that I mentioned. I would be cautious, and I would take advice before enforcing, making employment conditional upon taking the vaccine. As I say, we may well see Pimlico plumbers as being something of a bellwether in this. And I fully anticipate that is going to be one of the areas where there's going to be case law to come, I feel.
Thank you for that. Look, I'll wrap up because I think we've had a couple more attendees. Thank you. You know, great speaker and well presented. So thank you to Keith for his comments, and to Kieran, who offers his thanks. I'll also offer mine, Ewan, on behalf of everybody this afternoon. You know, really clear, which is always great. Lots of detail, really informative and very helpful. So look, thank you from and on behalf of the Institute of Financial Accountants and our members and attendees this afternoon. You know, thank you for your time. Thank you for your colleague Lucy's time behind the scenes. We look forward to, you know, hopefully having you back at some point in the future to cover something that is related to your area of expertise, and something that the members will be intrigued and interested in. But for this afternoon, thank you very much indeed for your time, and it's been a pleasure hosting. To members, to those who have joined us this afternoon, just a reminder, we have a host of webinars coming up covering a wide range of subjects and topic matters. Please do register. All of the detail is on the Institute website. underneath the CPD tag. Straightforward to sign up by following the link and providing a small amount of information. If anybody has any problems or issues, please do contact myself or my colleague Linda Wallace. Thank you to Linda, who again behind the scenes, sort of covers the technology and the polls. So these wouldn't run without her help and support as well. So Ewan, Lucy, Linda, thank you very much indeed. To everybody, have a good afternoon, stay safe, and we look forward to catching everybody. Well, the next webinar is in 2 days' time on the 18th. Thank you, have a good afternoon, and keep well. Thank you all.
Thank you.